infringing the copyright in Superman. Interestingly enough, this piece was actually part of the clip art from PowerPoint. When we first put this presentation together, when we updated the presentation, this piece of clip art was gone. I suspect somebody from Time Warner sent a letter to somebody saying, hey, get rid of this. And it's not there in the clip art anymore, so we have skillfully preserved it here. And we'll talk briefly about later on, why are we not infringing copyright by having this copyright infringing picture up here. And there is a reason, and we'll talk about that a little bit later on. But this gives you kind of a quick overview of how you do some of the analysis. We'll talk about now a couple of case examples. National Comics versus Fawcett Publications and Warner Brothers versus American Broadcasting, aka Superman versus Captain Marvel, and Superman versus the Greatest American Hero. In the first case, the characters were found to be substantially similar, hence copyright infringement. In the second, they were not substantially similar and no copyright infringement. Once again, I'm sorry, it was a really cool picture too. Ed McGuinness. So, this case decided in 1950 at the Court of Appeal, but the facts actually go back to just a couple of years after Superman was first created and appeared in comic books. There were a whole bunch of similarities. I'm not going to read through them all. If you're familiar with the characters, you'll have a general sense. I will draw your attention to one point that was significant. The court noticed that the Captain Marvel authors had actually lifted certain expressions and dialogues straight out of the script from some of the Superman stories. They didn't copy the whole script, but they had taken pieces of it. That was relevant in the court's conclusion. They talked about the mad scientist villains. And I just find this is a great quote by the court, who by similar devices attempt to dispose of the hero so that they can execute their plans of destruction without molestation. I'd just like to point out, it's not that kind of molestation. They weren't fighting Anthony Weiner. Okay, I try to keep it a little bit fun. So, what were the differences? Well, the court ultimately said the only real difference is the color of their costumes, with Superman blue and Captain Marvel red. So I've just drawn my own impression here of the costumes as interpreted by the court. See no infringement. Now, on the other hand, this is a fight that Superman lost. Superman versus the Greatest American Hero. Does anybody here remember that TV series? What, 2 people? Okay. A few more people. It was kind of this lame series that was a bit of a takeoff on the superhero concept that ran shortly after the Superman movies. And it featured this kind of reluctant, ineffectual superhero named Ralph Hinckley. And there were a whole bunch of similarities: strength, costumes, villains, flying, etc. I'll let you read them here. But the difference, the big difference that the court found was in the way this was expressed. With all of these powers, Superman is this brave, confident hero. Like when he lands and you're going to shoot at him, he just stares at you. And it's like, you really think a firearm is going to hurt me? Come on. Whereas Ralph Hinckley, even though he's bulletproof, when you shot at him, he'd be, ah! And he was sort of a timid, reluctant, tentative hero. He always crash-landed instead of the graceful flying. There were some other less important differences, but the court found that ultimately there were too many differences in the way the idea of this superpowered individual was expressed in terms of the origin, the mannerisms, the attribute for there to be infringement. So the ultimate test, although it's fact-dependent, is whether this average person for whom the work is intended would recognize that the alleged, that's accused copy, was taken from the expression as opposed to the idea in the copyright work. And it's not just visual resemblance that we're looking at, but the totality of the character's attributes and traits. One big point that came out of that Greatest American Hero case is that the court will not pay attention to attributes that are in the cultural milieu. So a lot of superpowers today are out there. They're common to the sort of superhero genre. Secret identity is now common. I mean, what superhero doesn't have a secret identity? I know, Silver Surfer, let it go. But at the time of the Captain Marvel case, superheroes were new. All of that stuff was new. It wasn't part of the cultural zeitgeist, so you weren't free to take it. As the cultural zeitgeist expands, you're more free to kind of take these elements that are just floating out there as part of a genre without there necessarily being infringement. I'm going to speak very quickly now about moral rights, which is basically your right to be associated with your work or to remain anonymous, and to the integrity of your work. So if you are the author, you have the right to have them say, yes, John Smith wrote this. Or if you think it's terrible and you're embarrassed, please, dear God, never mention my name in association with this work. You know, for example, Superman 3. Sorry. You also have the right to the integrity of the work, not to have people mess up your work and ruin it. The most famous Canadian case, which admittedly is kind of lame. How many people have seen the geese that fly overhead at the Eaton Center? A couple of people. One year, I think it was back in the 70s, they were actually created by a very famous Canadian artist, James Snow. And back in the 70s, for Christmas, they said, wouldn't it be cool if we tied bows around the necks of the geese for Christmas decorations? And he was furious that they were destroying the integrity of his artistic vision. And he sued them. And the court said, yeah, you can't do that. You completely changed the character of his sculpture. Take down the bows. So moral rights are potentially valuable. You can waive them, which is agree in writing not to assert them, but you can't actually sell them to someone else because they're personal to the author, although they do go to the heirs of the author when the author dies. And even if you sell your copyright, you don't automatically waive your moral rights. You might, if the contract is drafted properly. Typically when you sell your copyright, they will also make you waive your moral rights, but sometimes they miss it. And one time they sometimes miss it is they might be an American lawyer. Isabel will speak briefly to this.
Yeah, very briefly, for once, under U.S. law, it's actually easier than under Canadian law, and we don't have moral rights in the U.S. So you just don't have to ask yourself the question, and it's very weird in the sense that the rule is generally that there are moral rights, like in Canada and in other countries, but in the U.S. there's not.
So there's moral rights. So now, how do you protect your copyright? We've talked about what it is, how it comes into existence. How do you protect it? I'm going to now dispel probably the biggest myth out there that seems to show up over and over again, this thing, if I mail this to myself, I'm good. It's not. There's no legal protection associated with having somewhere in your file this sealed envelope with the post office date stamp on it. At most, that would be evidence that you could introduce in court, but it's fairly weak evidence. The key to protecting your copyright and making sure that you're as solid as you can be before you approach a publisher is registration, and we talked about that earlier, in front of a government office. Even though I'm a Canadian lawyer, I typically recommend that my clients do a U.S. registration because Canadian registration is kind of silly. You record the title of your work and the kind of work that it is, but you don't actually put a copy on file, so it's hard to prove what your work was. Isabel will speak a bit about U.S. registration.
Yeah, in the U.S. is the opposite actually. When you file a copyright application, you have to give a copy of your work. So if it's a comic book, you actually have to physically send an original to the copyright office, and they're going to keep the copy in the office. So if any time in the future you want to sue someone because they're infringing your copyright, you can actually prove what you actually get copyright for by using that. The good thing about registration is, one, it's not expensive, and it's a quick process. And the other thing that's very important about copyright registration is that in the event you want to sue someone in the US, you cannot sue someone if you do not have a registration. So that's a very important rule. And for something that is inexpensive and fast to obtain, it's really important to get that registration so you can sue someone.
In Canada, you don't have to sue someone, but having that U.S. registration is extraordinarily valuable because you get a certified copy from the U.S. government saying this is my work, this was when it was registered. Even in a Canadian court, that would be very, very strong evidence of what you created and when you created it.
And that's also the whole point of the registration under U.S. law. Whatever is on the registration certificate that you get, so the name of the author, the date it was created, the title, all the elements that are part of your copyright, those are going to be considered by a U.S. court to be valid and proper and correct. So it's going to be your adversary's job to try to discredit all those elements. But if you have a copyright registration, all those elements are going to be presumed valid, which is very important when you have to go to court.
Final point on protection is marking of your work. You can either use the whole word copyright or that cute little C symbol that comes up when you try to put a C in brackets. And that's the international symbol for copyright, and then you put the year. and the owner, not necessarily the creator. So I've put copyright 2013 Gowlings because that's my firm, and as I mentioned, they own it.
And the year, by the way, is not the year you created it, it's the year it's published. That's important to know.
So with that, we'll talk briefly about some of those exceptions. And we mentioned, how could I knowingly put up this infringing picture of Superman? Well, in the US, there's a concept of fair use. And in Canada, there's a concept of fair dealing. They're a little bit different in the details. But in the broad overview, you are allowed to make copies for the purpose of criticism, news reporting, research, parody, and in Canada, this is a brand new thing with our most recent amendments that just happened to the Copyright Act, non-commercial user-generated content, a classic example being fan fiction. As long as it's non-commercial and the other requirements of the statute are met, that's not going to be considered copyright infringement, which is actually pretty progressive for Canada to have express recognition for that. Just very briefly, we talked about that infringing Superman picture. It's up there. I made that copy for the specific purpose of criticizing the actual image itself. Now, I couldn't put other images in here, even though I might be talking critically about a court decision, because I'm not criticizing the actual work. But I can make a copy of the work for the purpose of criticizing it, as long as I do other things like attributing the source, which I did. I said it came from the Microsoft PowerPoint and so on. There's more details than this, so don't just assume you can rely on one of these exemptions. The rules are different in the US and Canada. Ultimately, in addition to the details, the real core takeaway is it has to be fair, either the dealing or the use. If what you are doing is perceived as unfair to the owner of the copyright, if you're, quite pardon my language, screwing them in some way, you're going to lose. It has to be fair. And typically they're looking at the question, are you cutting into their revenue in some way? So the fan fiction, for example, has to be non-commercial. Now, one final point on what we call not quite copyright, whether your comic book can feature a real person. This is a very brief overview. You will definitely need legal advice if you want to put someone who is real in the comic book. You will need their permission because people have the right to control and commercially exploit their own persona. Do not portray the person negatively. And I'm hoping Todd McFarlane is still signing stuff and hasn't stopped up here, because some of you may have known he lost a $25 million defamation lawsuit against a famous NHL player when the court ruled that there was a mobster character in the Spawn comic who was pretty clearly that NHL player and was pretty insulting. So I'm not making that up. So be very, very careful about portraying real people or inspired by real people if you're doing a negative portrayal. There are certain exceptions to that, but again, they differ. The rules differ in the U.S. than in Canada. It's very, very complicated, as I mentioned. You're going to need legal advice for that. We'll take questions at the end, if that's perfect. So I want to briefly go over trademark, which we're going to go through much more quickly, because it's more tangentially connected to comic books. What is it? Trademark is a mark that indicates the source of your product or service and distinguishes your product or service from those offered by other people. So a consumer will feel assured that they're going to get a certain level of quality when a product or service bears a trademark that they recognize. You could go into a McDonald's anywhere in North America and you're going to know what you're going to get. May not be the highest level of quality, but you know what to expect. You know what the McDonald's trademark means in terms of what you're going to get there. Types of things that can be trademarked, titles and names. So character names can be trademarked. The title of a comic book can be trademarked, subject to an interesting point in the U.S.
Yeah, in the U.S., interestingly for trademarks, if you want to get trademark rights for a title of a book, I'm only talking about titles, not the other stuff, you have to actually have more than one book. So if you have 2 books with the same title, you can get trademark rights. But if you only write 1 book with that specific title, you won't get trademark rights out of it.
So for a one-off graphic novel or something like that, might not be protected. The title might not be protected. You can also protect symbols, logos, and designs. How many people know the little bat symbol with the yellow oval around it? The story behind that, in the 60s, when they were launching the wonderful Batman TV series with Adam West and Burt Ward, they went to try and trademark the bat logo, and the trademark lawyer said, you're not going to get a trademark for just a bat on its own, it's too indistinct. You need to do something to it. So they said, what if we like put an oval around and color it in? And they said, yeah, that works. And it's true, that's where that yellow oval bat symbol came from, was they wanted to be able to get a trademark registration so that they could have trademark rights for all of the merchandising that was going to spin off of that show. Costumes or costume elements can also be trademarked. Think about, for example, Captain America's shield. There's an example of a trademark costume element. Now there's different kinds of trademarks. Now we're talking particularly more about words than images here. And you'll see this arrow which shows those at the top are given more protection by the courts and those at the bottom are given less. Unique trademarks are those where it's a completely made up word. Xerox was not a word that existed before until they made up that word. So it's a unique trademark. It gets a very high degree of protection. Next are what's called arbitrary trademarks, where it's a real word, but it has nothing to do with the product. So Dove, for example, it's a bird, but it's nothing to do with soap, and it has nothing to do with chocolate. Some of you have seen Dove, and we'll talk about why is there Dove soap and Dove chocolate. We'll talk about that in a minute. Suggestive trademarks are weaker still. Huggies suggests what a diaper or a good diaper will do, but it doesn't clearly describe it. And descriptive, all brand. I mean, okay, it's all brand.
And
right?
descriptive marks, by the way, are not protected at all.
Exactly.
Yeah.
They have virtually zero protection. So, I use this silly example. Science fiction comics is not a good name for your science fiction comic magazine because you'll get no protection for that. So how do you get it? One way, not the best way, is through actual use, like selling products that actually have the trademark on them. This is what's called common law protection. The reason it's not great is you don't get the rights unless you had a lot of use over a long period of time, leading to a very strong reputation in the trademark. And you may have geographic limitations. So it may, your rights may be limited to one part of the country, and you also have to prove those rights in court. A better way is federal registration of the trademark. And you can do that both in Canada and the US. And that federal registration gives you instant rights as soon as it's, not as soon as you apply, but as soon as it's registered. You have nationwide rights to that trademark. But an important point Isabel will speak to.
Yeah, one important point to always remember, whether it's for a trademark or a copyright, is that when you apply for registration, you only apply for that particular country in which you go. So if you want to get rights in Canada, you need to apply for a trademark in Canada. You want to get rights in the US, you need to do the same in the US. It's territorial. And another thing that's very important, the distinction between copyright and trademark, is that, I don't know if you remember earlier, I said that for copyrights, you cannot sue somebody in the US unless you have a registration. For trademarks, you can sue somebody in the US if you do not have a registration. However, by getting a registration, the same thing for copyright, everything that's on your registration certificate, so the owner, the date that you first used your mark, all those things, there's going to be a presumption that they're valid, and it's going to be your adversary is going to have to prove they're not. So that's a very big advantage in court.
Particularly with trademark, it's important to register in every country where you want to enforce it. Has anyone ever heard of Marlboro? Okay, well, Marlboro makes what?
Cigarettes?
Cigarettes, right. Well, Imperial Tobacco owns the Marlboro trademark basically everywhere in the world except Canada. There's a tiny little cigarette company that back in the 1930s registered the Marlboro trademark for cigarettes. And they've been in epic fights and confrontations with Marlboro probably once every 10 to 15 years as their lawyers come up with a new way to try and attack this registration. They sell about like 30,000 cartons a year, not a huge amount, but they own the registration. And so Marlboro cigarettes, you'll notice you'll never see Marlboro brand cigarettes in a Canadian store. Recently they had the same package except without the word on it. They just had the red roof logo. That's because a different company owns the trademark rights in Canada. So get the rights in every country that you want to sell, because someone might scoop you if you don't have any presence yet in that country.
Another cool thing you can get with, if you get a registration, and I'm only talking about the US, if you get a trademark registration in the US, and let's say for a book, for example, and that's the title of your book, and then in China somebody decides to bluntly copy your book and publish it, and then they want to import those counterfeit copies in the US, if you have a registered trademark, you could block them, and at the customs, basically block them from getting the goods inside the country and selling those counterfeit goods. So that's important for those type of purposes.
So, and that's one of the rights you get with a trademark registration. Now, the trademark is going to be limited to the product or services for which the mark is registered. So, we use the example of Dove. Dove for soap is limited to soap and certain related products, and Dove for chocolate is limited to chocolate and certain related products. So you've given official notice to other people that the trademark is taken for that product or services. There's a register that you can go and search, it's on the internet. And if someone uses your mark or one that's confusingly similar to sell similar products or services, you can sue them. But soap is not very similar to chocolate, unless you do weird things in the bath that I don't want to know about. So, you know, they're free to kind of coexist. But, so it's a question of how similar it is, so you're going to be limited to that. Some trademarks are going to end up, there'll be multiple trademark registrations for various goods. Coca-Cola is probably a classic example. If you ever want to spend a few days being really bored, you can look up all of Coca-Cola's trademark registrations, because it's not just for soft drinks. They have registrations for soft drinks, they have trademark registrations for chairs, just about everything that a Coca-Cola brand has been applied to. They're very good about having a lot of trademark registrations, so you can expand as your brand becomes more famous. You can register the mark for more and more goods to support your merchandise.
However, one good point to know is that, and I'm sure there's probably a similar theory in Canada, but in the US, when you have a famous mark like Superman or Coca-Cola, if somebody starts using your mark for something that has nothing to do with, for example, a comic book, and starts using your mark to sell chocolate or something that's completely unrelated, you will still be able to sue them, even though you don't have protection for chocolate, because you have a famous mark, and by that person using your mark, they're basically, the term is diluting, they're diluting the value of your mark. So don't be fooled that it's not because you're using somebody else's mark for something that's completely unrelated to what they were selling that you're not infringing their mark. If you have a famous mark, you pretty much have very strong rights.
Okay, so we're going to wrap up now. The big takeaways here, number one, copyright protects expression of an idea, not the idea itself. So draw your character out, flesh out the details as much as you can in writing. You're going to infringe someone else's copyright if you have access to their work and if their work is substantially similar. And registration of copyright and trademark is going to provide the best and most thorough protection for a creator. I want to very quickly give special thanks to Giselle Chin, my articling student, who was very helpful.